Hello everybody, welcome to PW OnlyIAS YouTube English medium channel. Hope you're all doing great today. We are here with the 9th chapter of Indian Polity, that is Directive Principles of State Policy. Without any further delay, let me take you right into the chapter. But before that, this is my official Telegram channel where you can ask your doubts with regard to Indian Polity. You can send in your answers of PABAD, all the 4 GS and essay. Please ensure that they are all PYQs from 2013 onwards. All right. In addition to this, if you require the PDF of these classes or lectures, what I am taking, especially the PowerPoints, etc., in the PDF format, this is the place where you can access it. All right, people. So, without any further delay, taking the discussion forward, the introduction to Directive Principles of State Policy. First of all, it comes under Part 4 of the Constitution from Article 38 to 51. Article 36 is basically, now generally it is 36 onwards. All right, 36 onwards it is. But 36 is actually what? Definition of state. And Article 37 talks about the nature and significance of DPSP. But 38 to 51, you have the principles put up over there. 36 and 37 is nothing but definition of state as well as the nature and significance of DPSP respectively. Irish Constitution of 1937. That is where we borrowed the idea from. And from whom did Irish borrow the idea from? They borrowed it from the Spanish Constitution. Dr. B.R. Ambedkar called it the noble features. DPSP plus fundamental rights is called the philosophy and the soul of the Constitution. Granville Austin has called it the conscience of the Constitution. So one must understand here, directive principles of state policy is basically a directive, or it is like a set of instructions that is given to the state as to what you should do, how you should do. That is basically how you should rule the country. What are the principles or guidelines that needs to be followed? That is the purpose of directive principles of state policy. Clear, people? So, moving on to the next topic, the features. Let us start seeing them one by one. Ideals that state should keep in mind while formulating policies and making laws. Again, it is a reminder to the state how you should make laws, for whom you should make laws, how you should make the policies, schemes, etc. Constitutional instructions or recommendations to the state and its organs, basically, that is the legislative, executive, and administrative matters. Getting the point here? That is, it is basically a set of instruction to the government, what you should do, how you should do, etc. As you can clearly see, you don't see judiciary here. Why? Because it is entirely for the parliament, the state legislative assembly, the union government, the state government, the local governments, etc. Moving on, state has the same meaning as the one in fundamental rights. That is, in fundamental rights, we would have defined what is the state. So even private companies who are doing the work of the government on a contractual basis, even they will also come under the definition of state here. Includes legislative and executive organs of center, state, and local bodies. DPSP resemble instrument of instructions enumerated in Government of India Act 1935. So it is resembling it. Comprehensive economic, social, and political program for a modern democratic state. That is what DPSP is about. Economic, social, and political program. DPSP aims at realizing JLEF, justice, liberty, equality, and fraternity, as mentioned in the preamble of Indian Constitution. It establishes, or it seeks to establish, a welfare state. That is basically egalitarianism, equity, reducing the inequality, trying to bring up the disadvantaged sections of the population and bring them on par with the well-off population. These are the fundamental goals behind directive principles of state policy. Establish social and economic democracy. Social and economic democracy, that is bringing everybody, all are treated equally through the policies and the laws. everybody have the same set of economic opportunities through the policies and the laws. And the most significant aspect is non-justiciable. Non-justiciable simply means, now if my fundamental rights are violated under Article 32, I have constitutional remedy whereby which I can directly go to the Supreme Court. It is a fundamental right itself. To enforce my fundamental rights, I can directly approach the Supreme Court. That itself is a fundamental right. Means it is justiciable. Supreme Court has again said that where relief is available for violation of fundamental right through High Court, if it is available, one has to approach the High Court first. And yes, under Article 226, I can approach the High Court first in the event my fundamental rights are violated. However, when we say DPSP is non-justiciable, what it simply means is I cannot go to the court and tell that, see, state government is not doing this. State government is not following DPSP. Nor can I go to the court and drag the central government, nor the panchayat, nor the municipality, or any organ of the government, be it executive or legislative. I cannot drag them to the court telling that they are not following the principles of the directives given in DPSP. I cannot drag them to the court. That is what it means. So ultimately, what is the bottom line? These are just guidelines for the state when it comes to making policies or framing laws. They are fundamental in the governance of the country, helps court in determining the constitutional validity of the law. That is when you take it for comparison between FR, that is fundamental rights, and DPSP, when a law is passed, court will basically look into whether which one has to be given more preference here, whether it should more preference should be given to DPSP or more preference should be given to fundamental rights. Clear? Supreme Court ruled many times, if law seeks to give effect to DPSP, it may consider such law as reasonable in relation to Article 14 or Article 19 and thus save such law from unconstitutionality. Means what? That is, if a law is passed, okay, which will give if in order to realize the goals of DPSP. But in the process, what is happening is Article 14 is getting violated, Article 19 is getting violated. And these two are fundamental rights. So if a law seeks to give effect to DPSP, any of the principle of DPSP, but it will violate the fundamental rights, still the court will not, or rather may not, declare the law as unconstitutional. It depends from case to case basis, mind you. Case by case it will depend. Not that blindly, oh, you are trying to give effect to DPSP, then fine. Even if you violate fundamental rights, we won't bother to call the law unconstitutional. No. Case to case basis only it will be decided. Clear, people? Taking the discussion further forward. Classification of the directive principles. There are three types of directive principles actually. If you categorize all the principles, there are three types again. Socialistic, Gandhian, liberal intellectual. Now, why we have made this categorization, you will get the idea once you start going through these principles. So, socialistic principles, if you see, they reflect the ideology of socialism. It is a framework of a democratic socialistic state. So, socialism, when we say, you must understand one thing, it is more about what? Creating an equal society where private ownership is given lesser importance and public ownership, sharing of resources, reducing concentration of wealth in the hands of a few. These are some of the guidelines. And it provides for a social and economic state. It's a path towards welfare state, something which we have seen already. They direct the state to do what? Article 38. Welfare of people by securing a social order permeated by justice. To ensure a social order that is marked by justice. What type of justice? Social, economic, and political, where one has to minimize the inequalities in income, status, facilities, and opportunities. The second provision was added by the 44th Constitutional Amendment. Then you have Article 39 to secure adequate means of livelihood, equitable distribution of material resources of the community for the common good. Equitable distribution, not equal distribution. Equitable, that is the one who is having very less, you give them more. The one who is already having, you give them a little less. The same logic is applied when it comes to the distribution of taxes between the center and states as per the recommendations of Finance Commission. In that, the less well-off states where the HDI factors are very poor, those states stands to get what? More fund transfers. Percentage wise, I'm talking about. The states which are already well off in terms of HDI, they get lesser. Why? To create equitable development. Getting the point? See, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of the health and strength of workers and children against forcible abuse, opportunities for healthy development of children and youth against exploitation and against moral and material abandonment, added by the 42nd Constitutional Amendment Act. That is, again, only a portion of it has been added. Clear? Moving on. Article 39. Promote equal justice and to provide free legal aid to the poor, added by the 42nd Constitutional Amendment. Article 41. To secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. Article 42. To make provision for just and humane conditions of work and maternity relief. Article 43. To secure a living wage, a decent standard of life, and social and cultural opportunities for all workers. In the textbook, basically, they have clearly given what you mean by a living wage, a fair wage, daily wage, etc. Those breakdown is given. Please go through it. Article 43(a) to take steps to secure the participation of workers in the management of industries, again added by the 42nd Constitutional Amendment Act. Article 47 to raise the level of nutrition and the standard of living of people and to improve public health. Coming to the next topic, that is Gandhian principles. Now you look over here, it represents the program of reconstruction enunciated by Gandhi during the national movement. The program of reconstruction, what he focused on during the freedom movement. Article 40 talks about village panchayats that are supposed to function as self units of government. That means to give more freedom to the village panchayats. Then Article 43 talks about promoting cottage industries at individual or on a corporation basis. Article 43(b) talks about cooperative societies, which was added by the 97 Constitutional Amendment Act, where they should be given autonomy, democratic control, and professional management. Article 46 talks about the welfare basically of SCs and STs, how by providing them with education and economic interests, improving it, reducing the social injustice and exploitation to which they are subjected to. Article 47 talks about prohibiting drugs and other intoxicating drinks. That is basically reducing. The state should basically discourage actually from the promotion of alcohol or alcohol products. Reduce it so as to reduce the consumption. But what is the reality? Most of the state governments actually depends on alcohol's sales for their revenue. It is a reality. Article 48 prohibits slaughter of cows, calves, and other milch and draught cattle to improve their breeds. All right. Coming to the final part, liberal intellectual principles. Article 44 talks about bringing a uniform civil code, and that is a very contentious topic even today in the present political scenario in our country. Article 45 provide early childhood care and education for all children until they complete 6 years. Originally, it was 14 years, but that changed after the 86th Constitutional Amendment Act. Article 48, organize agriculture and animal husbandry on modern lines. Article 48A, protect and improve the environment and to safeguard forest and wildlife, added by the 42nd Constitutional Amendment. Article 49, protect monuments, places and objects of artistic or historic interest which are declared to be of national importance. Article 50, to separate the judiciary from the executive. In public services of the state, very important article. Separating the judiciary from the executive is an article which you will have to remember whenever you are writing your GS paper 2. All right. Article 51, international peace and security, good relations, respect for international law and treaty and obligations, settlement of disputes by arbitration. So, here this is the most important article. I know this sounds very cumbersome, sir. How to remember all of this? Just repeated reading, people. Other than that, nothing else to do. Because if you try to by heart it, you will get confused. Because you require it basically more in your prelims actually, at least to identify which belongs to where. So at least for that purpose, repeatedly you have to read it. All right. So you need to actually do a repeated revision to understand which falls under where. Other than that, there is no shortcuts for this, unfortunately. Okay, people. Taking the discussion further forward, new directive principles. So when we are talking about new directive principles, we are basically talking about, compared to the original constitution, what new principles were added through constitutional amendment. Through the 42nd constitutional amendment, added Article 39, which is what? Secure opportunities for healthy development of children. Article 39A, promote equal justice and to provide free legal aid to the poor. Article 43A, secure the participation of workers in the management of industries. Article 48A, protect and improve the environment and to safeguard forests and wildlife. Coming to 44th constitutional amendment, states should minimize inequalities in income, status, facilities and opportunities. Article 38. 86th constitutional amendment, elementary education, a fundamental right under Article 21A. The subject matter changed. 97th constitutional amendment, which is with regard to cooperative societies, Article 43B. All right, this part you have to remember, which were the new DPSPs that were added. Clear, people? Taking the discussion further forward, sanctions behind directive principles. Why they are non-justiciable? Why? Why have we not made them justiciable just like fundamental rights? First reason is country did not have sufficient resources. We were a very poor country back in 1947. Vast diversity and backwardness. Such a diverse population, almost many multiple issues at that point of time. Tribal issue, then later Naxal issue, issues with Pakistan, issues with China, then issues with refugees. So it was a Pandora's box basically in the initial years after independence. And again, too many preoccupations. There were so many things that we were bothered about. 47, 48 itself, we had the first war with Pakistan, the Kashmir war. And later years also, if you see, it was not that India could enjoy some peace at any point of time. 47, 48, you had war. Maybe the decade of the 50s was largely silent. But the 60s, it was again, 60s and 70s again filled with war. 62 China war, 65 Pakistan, 71 Bangladesh liberation war. 74 we went on to do nuclear test, followed by that we got sanctions. So every stage of progress from 51 to 91, you will basically see what we were having so many troubles. So at this point of time, it was not possible to actually make DPSP justiciable, because anybody could file a case and tell that, see, government is not doing this. So it would have been very difficult for the government to focus on any particular policy. Now, let us look into how fundamental rights is different from DPSP. Fundamental right is negative, as it stops the state from doing anything. Whereas directive principles of state policy, it is positive. Why? It asks the state to do something. FR is justiciable. DPSP is non-justiciable. Fundamental rights ensures political democracy, whereas DPSP ensures social and economic democracy. Legal sanctions are there. That is, if my fundamental rights are violated, I can go to the court. Here, it is only moral and political sanctions. Why moral and political we say? Moral we know because a government also should have some ethical principles. When you are not doing or when you are not taking any steps to improve the welfare of the people, then obviously it's a bad thing. Now, how is it political? Political sanction means you are not following the guidelines of DPSP. That automatically means what? It becomes a weapon at the hands of the opposition. So they can basically use this as a weapon and criticize the government, telling that the government is not at all following DPSP, or the government is violating the idea of democratic state or a welfare state. Opposition can use it. FR is about welfare of the individual, whereas DPSP is about welfare of community. Whereas while FR is personal and individualistic, DPSP is societarian and socialistic. It is automatically enforced. You don't require a law to be passed to enforce fundamental right. But in the case of DPSP, you require legislation. Specific laws have to be passed to implement the values or the idea behind DPSP. Courts can declare law void for violation of FR. If a law actually violates fundamental right, court can declare the law as what? Unconstitutional. Classic example, or a scheme also. The electoral bond scheme is the one that comes into memory in the recent times. Courts can uphold a law even if it violates the fundamental right, if the idea behind passing such law is to give effect to DPSP. Again, case by case basis, this will matter. Taking the discussion further forward, criticism of the directive principles. So why are directive principles being criticized? First of all, there is merit to it. It does not have any legal force. That is, you cannot drag the government to court. You cannot do it. Second, it is illogically arranged, which is very, very true. If we try to by heart it, even we will get confused. Okay, this comes under social or it comes under Gandhian. Okay, how did this come under liberal intellectual? No idea. It is very conservative. That is, some of these principles may not actually cater to a progressive society. So uniform civil code itself, when we say, we are trying to bring what? One single rule, civil rules for the entire country. But that definitely will tamper with the minority rights. Getting the point? Now, when a progressive society, what is the idea here? The progressive society's idea is live and let live. As long as your customs, culture, whatever religion you are following does not interfere with my customs, my religion, my belief, you follow what you like, I will follow what I like. That is the whole idea of a progressive society. But when you try to bring one single rule, uniform civil code, etc., it will violate that, because what it means is we don't care about what your custom or belief system is. One single law for marriage, one single law for inheritance, one single law for both men and women equally in the country. So another aspect of it is what? It will bring clarity. Courts need not actually dwell upon, okay, should we follow the personal laws of the religion or should we follow the Bharatiya Nyaya Sanhita and the other laws, whatever latest laws have come, should we follow that? Courts also will not have a confusion. There will be a clarity here. Just follow the code. Constitutional conflict. Again, true. It has always led to what? Conflict between FR and DPSP. That has always happened, and history is rife with it. Taking the discussion further forward, utility of directive principles. So criticism we saw. So then what is the use of it? It is like an instrument of instructions to all authorities of the Indian Union. Indian Union, when we say, please understand, states, panchayats, municipalities, all are included here. Reminds them of new principles of social and economic order. That means it is not the police state or a tax collecting state. It is a welfare state. So you have to follow those principles which will ensure social and economic democracy in the country. these are useful beacon lights to the courts to determine constitutional validity of a law. Understood? That is, DPSP is there. That is the reason why court is also able to see whether we should allow this law or whether we should declare it as null and void. Then, dominative background to all state action and guide to courts. That is, ultimately every state action, if you see, it is directly or indirectly guided by what? The directive principles of state policy. Amplify the preamble. Obviously, like we already saw, justice, liberty, equality, fraternity, and justice again, social, economic, and political. Clear? Stability and continuity in domestic and foreign policies. Under liberal intellectual principles, we know it is important to maintain good diplomatic relations. And there should be some stability in what? Domestic and foreign policy. Why? Governments will keep changing. Just because the government changed, we cannot say, right, okay, that was signed by the old government, I don't care about it, now I want a fresh agreement. No, you need to maintain continuity in governance in the country as well as the diplomatic relations that you have been maintaining with the outside world. Supplementary to the fundamental rights. It is in addition. It is not complementing it. That is, it is not supporting fundamental rights. This is in addition. So it's like both are going parallelly. DPSP in its own lane, fundamental rights in its own lane. They help in enjoying economic democracy. Opposition can use them for influence and control over the government. Crucial test for the performance of the government. Last one, it is a common political manifesto. That means it is a common guideline for any party that is trying to contest election or come into power. Every political party can refer into this as to how they should frame policies or schemes. Getting the picture here? Moving on. Conflict between fundamental rights and directive principles. Now, in this section, basically, we are going to go through the history, how things evolved. Long story short, I will tell you, fundamental rights have the upper hand over DPSP. But in that, again, one small twist is there. Let us see that towards the end. So, how did it all start? In the Champakam Dorairajan case, fundamental right would prevail in case of conflict. That is what Supreme Court ruled. If conflict is there, fundamental right would prevail. But the Supreme Court did not stop there. They made another ruling also. One more statement they made. And what was that statement? The statement was basically, Parliament could amend. Parliament could amend the fundamental rights. They can amend it. Following this, what happened? The Parliament also did not waste any time. They immediately passed the first, fourth, and the seventh constitutional amendment was passed. Later, in the Golaknath case of 1967, Parliament cannot take away any fundamental right that was sacrosanct. Sacrosanct means like it is the main thing. It is as pious, very religious, untouchable. You are not supposed to tamper with it. Fundamental right cannot be amended for implementing DPSP. Golaknath case, because it is our Supreme Court after all. They will say one thing initially, after 10-15 years, they will change their stand again. 1967. 24th Constitutional Amendment was passed where Parliament basically ruled what? They can abridge or take away any fundamental right. 24th Constitutional Amendment. We can make changes to fundamental right also. We can take it away also. That is any fundamental right. 25th Constitutional Amendment, Article 31C was inserted. What is Article 31C? Simply means any law, and it had again two provisions, which we have already seen in the earlier chapter of fundamental rights. So any law that is passed to give effect to Article 31C, even if it is violative of fundamental right, it will not be unconstitutional or void. Simple. Under Article 31C, two provisions are there. What are those two provisions? Please refer back to the earlier videos on fundamental rights. So two provisions are there. Under that two provisions, to give effect to Article 31C, if a law is passed, it will not be considered as null and void or even as unconstitutional. That means any law passed to give effect to Article 31C is valid. That was the 25th CA. But in the Keshavananda Bharati case, Article 31C was declared unconstitutional. Why? Because you cannot basically protect any law from judicial review. Why? Judicial review is a basic feature of the Constitution. 42nd Amendment Act. Protect DPSP, not just Article 39B and C, legal primacy and supremacy to DPSP. So, following the Keshavananda Bharati case, which literally brought in the whole concept of basic structure or basic feature, what happened? 42nd Amendment Act was passed, where they basically said that DPSP will have an upper hand. Not just the laws mentioned under Article 39B or C. Every law, if it is to give effect to DPSP, DPSP will have the upper hand. Then, in the Minerva Mills case of 1980, Supreme Court declared the above as unconstitutional, but fundamental right under Article 14 and Article 21 were made subordinate to Article 39B and 39C. Simply means what? Supreme Court basically told that this provision here, the 42nd Amendment Act, which seeks to give full power to DPSP, Supreme Court called it unconstitutional. But instead made one clause also there. And what was the clause? If a law is passed to give effect to a DPSP, even if it is violative of Article 14 and 21, in such a scenario, the law will not be void, will not be unconstitutional. In other words, laws that will come under Article 39B to give effect to Article 39B and 39C was made superior to the fundamental rights of Article 14 and Article 21. When in the Minerva Mills case, Article 31 was finally omitted by 44th Constitutional Amendment Act. We know right to property. Present position is what? Fundamental right is supreme over DPSP. That is the present position. But in that I told you again, there is a small twist. What is the twist? Parliament can amend FR, fundamental right, to implement DPSP as long as they don't tamper with basic structure. That means Parliament can amend fundamental rights for what? To implement DPSP. But it should not tamper or affect the basic structure of the Constitution. Basic structure you are not supposed to touch. Without touching the basic structure, how can you amend the fundamental rights? Some of you might be thinking, 99.999999%, it is not possible. It is not possible because you touch a fundamental right, amend a fundamental right, it will eventually what? Somewhere or the other, it will affect the basic structure. That is why, as of now, what is the position? FR enjoys superior status over DPSP. Clear? Now, this is very interesting. Why? Because very recently also, right to property. Again, we are going back to that law, where the court made it very clear. Whose public purpose? Which community is going to get benefit out of it? And how is it a resource for the community totally? These are some of the valid questions that Supreme Court asked if the government is going to take away the private property of an individual. That is, in other words, the private property gets protection today. Simply the state cannot go and grab it in the name of what? This is for community purpose, this is for transferring the resource to the community, or this is for public purpose. Who cannot do? State cannot do. And in that case also, if you notice, when you are taking away somebody's private property and giving it to community, it is equitable distribution. prevention of concentration of wealth. All these are DPSP. And right to property, if you notice, it is not even a fundamental right. It is only a legal right or a constitutional right. That's it. It is there in the Constitution under Article 300A. So for a legal right, this level of protection is there, where the state has to prove it. It is the responsibility of the state to prove. It is for public. It is for community. It is to realize the goals of DPSP. Won't work. Won't be easy. So to take away a legal right or to take away a constitutional right itself, this much of steps have to be taken means, imagine fundamental right. Getting the point here. So this is why I was telling you, I mean, in the Titan class also I had this discussion in the current affair class where I told you very clearly, somewhere, right to property has almost got elevated. Its stature has got elevated and it has come very close to FR. Because fundamental rights are also not absolute. It is only qualified. The state can impose reasonable restrictions of it. That is, the state can take it away from me under certain special circumstance. If you actually notice, the current ruling is almost doing the same thing only, right? Until and unless the state cannot satisfy the conditions set forth by the Supreme Court, nobody can take away my property also. Got the picture here? The only catch is what? Oh, my property has been taken by the state. I cannot use Article 32 to go to the Supreme Court. Maybe Article 226, yes, I can approach the High Court. That the state did not follow the guidelines as set forth by the Supreme Court and my property was taken away from me, I can approach the High Court. Not Article 32. But otherwise, if you generally see, the bottom line is what? With a constitutional right or a legal right itself, we can see it is having supremacy over DPSP. The latest ruling I'm talking about. So fundamental rights means it is even more supreme. So it is literally or practically impossible to amend a fundamental right to give effect to DPSP without tampering with the basic structure of the Constitution. Clear, people? Taking the discussion further. Directives outside part 4. The last topic probably. Claims of SC and ST to services. That comes under Article 335 part 60. Instruction in mother tongue. Article 350A part 17. Development of the Hindi language. Article 351 part 17. Alright, so these are the other directives that are there. Instruction should be given in mother tongue, and to give effect to it, for example, you have Bhashani. Bhashani service is that. What is Bhashani? Please Google and find it out. It involves the usage of AI. Alright, and claims of SC and ST to services with regard to matters of appointment and promotion. Development of the Hindi language. Again, it's a directive principle only. That do not come under DPSP. They are kept separately in the Constitution under Article 351 part 17. That is the reason why there is a Hindi day, etc. are being celebrated in government office, etc. etc. Again, to promote it, basically to ease the communication gap. Getting the picture here? With that, we come to an end of our class, people. Once again, you may refer this channel to get the current PPT or in the PDF format. You can log into this channel here. Let me know how this class was, as well as what other suggestions do you think are necessary. Also, give me your take on the Supreme Court's intervention with regard to right to property. What do you think about it? All right. So, nothing further to add. Have a fantastic day. God bless. Take care.